updates. Emily, we do have a lot of things to cover today, especially on the Biden administration is coming into power tomorrow. And as soon as he's coming into power, he's bringing a new bill into picture. That's a very good thing that he's doing. We need to stop. We are here live from Houston, Texas, every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. We have some technical difficulties, so we have to do it again. But Emily, coming to the point, the Biden administration is coming to power tomorrow. And then he's saying that he's going to introduce a bill tomorrow. What do you speak about that?
Yeah, so this is quite different from the previous attempts at comprehensive immigration reform or any kind of major immigration reform bill. You know, when Obama was in power, nothing was done until the second term, and at that point it was too late for reform to happen. Same thing happened in the past with the Bush administration. So this is, I think, the first time we're having a president coming in and immediately on day one planning to propose a comprehensive reform bill. We've kicked the can down the road long enough. It's time to actually get something done. Now, will this pass? That's a different story. It's all stuff that has to be done in Congress. What are your thoughts on, you know, when are we going to actually see the text of the bill? Who's introducing it?
Thanks for all the comments for the audio, guys. Thank you, Kim. Thank you, everybody from Facebook. Emily, it seems that Senator Menendez from New Jersey is the one who is going to present it. We yet don't know whether it's going to be a bipartisan bill or it's going to be a straight bill. Normally, these kind of huge bills, though, they actually should be a bipartisan bill. And we all know that major immigration bills should only start in Senate. They should not start in the House of Representatives. So it seems to be the right path when Senator Menendez is the one who's going to introduce this in the Senator Menendez is the person who is going to introduce this bill in the Senate. So that's where the whole thing starts, Emily. What do you think things will be there in this bill, though?
Well, we have some rumors until we see the final provision of the bill. We don't exactly know, but there are several provisions that were extremely helpful for employment-based immigration, such as eliminating the per-country cap. That's going to be huge. Eliminating dependents from being counted towards the cap. That's going to be huge. Recapturing the 220,000 green cards that went unused from decades before. That's going to be huge. Just that on the green card side is going to be a major impact to many of the people who have been watching the show and have been supporting S386 and HR 1044. I think you get a lot of what you are hoping for through that. They're also going to, what other provisions are there in this bill?
One thing I'm expecting, as you know, that per country quota limit is going to be a big deal for a lot of employment-based people, where people have been waiting for a long period of time. I'm also expecting some of the unused green cards that were not being unused green cards that were not being there. The unused green cards should be given to the ones that were being wasted from 1992 to 2002 should be given back to them. That's one thing. There's also things that I do hear that they may not be counting the family members. That is going to be huge if that happens. The family members, if they don't, out of the, how much percentage of the green cards are given to the main applicants? How many percentage of the people are given to the
majority go to dependents, like 40%,
yeah,
right?
44 to 56%. So only 44% people are getting a green card. Rest of the people are dependents. So this bill, we're expecting that they're not going to count the family members. That is going to be a good thing if they do it. It's a very intelligent thing instead of increasing the numbers. For example, if you are in a H-1B, are they counting the H-4s? They're not counting the H-4s. Why are we counting the family members? They should be counting the family members. So that's an intelligent thing that they could do. We're also doing a lot of things with regards to people who are in the United States on or before 2013. They may be getting a pathway for them to get the green card and eventually citizenship. It looks like the pathway to get the green card seems to be somewhere about 6 years as compared to when the original bill was introduced in 2013 with a gang of 8. That's some of the changes in it. It doesn't look like this bill has any border protection or anything included in it. Even though the Democrats are calling this as a bill, that is not comprehensive. When I read the bill, I think it is definitely a comprehensive bill. It definitely is a comprehensive bill that has all the things covered. There may be some of the things that are not covered in. One thing is clear, Emily, that this administration is hell-bent on getting the immigration on a fast track. They don't want to do it. I mean, we know that Trump administration never wanted any of the immigrants. According to him, immigrants are undesirable people. But the previous two administrations, especially that I am more knowledgeable about, is Obama administration and Bush administration. Both the presidents, Obama and President Bush, wanted a comprehensive immigration legislation bill to be passed. But both of them waited for a long period of time. They waited. President Bush waited. Nothing happened in the Congress. Then we have Obama, who had House of Representatives under he has a majority in the House of Representatives. He had a 60 majority in the Senate, but he didn't put the immigration bill in the first 2 years. Then things changed. House went back, and even though the bill got passed in the Senate, it never passed in the House. So Biden looks to be very smart. I mean, he is getting the things much faster, and especially when he has a majority in the House and he has a majority in the Senate, he could get the things faster. Who knows, 2 years from now, he may lose the majority in the House. Typically, what we have seen in the House of Representatives is, even when the time of Clinton, the first 2 years, Clinton had a majority in the House. And then what happened? Clinton, after 2 years, he lost. Then we had Bush, who came into power. First 2 years, he had the House of Representatives. Then he lost. Nancy Pelosi became the speaker at that point of time. I'm not sure it was not. Then we had Obama that came into power. For the first 2 years, Obama had the House of Representatives. Then he lost. History tells us that when the president comes in, they will have the House, and then they will lose it. President Trump, he had the majority of the House in the first 2 years. He lost it later on. There is a good chance that the Biden administration may lose the House 2 years from the line. So from this time, so this is the proper time for him to do it. He's doing very good. Now, do you think that he's going to neglect the other things while this bill is pending, Emily?
Well, yeah, I think that there's some risk of that. I think he's going to take action on the executive orders quickly, because those don't require Congress. But at the same time, will he move forward with new regulations quickly? If he's planning on having an entire new immigration system, maybe not. So perhaps the focus will be on getting this reform through, and if that fails, then maybe we'll start on some of the regulatory reforms. I also want to mention one of the provisions, rumors, is that the H-4 EAD will be included in this bill, which means it will become statutory, not regulatory. That means that it's not up to the president or an administration whether to allow for it or not, like it currently is. It would be more like an L2 EAD. So that would also be a major benefit of this bill. And I believe some provisions for PhDs, STEM PhDs, would not be counted towards the green card cap as well.
Okay, and while we are doing this, we had this midnight regulations that have been passed last week, called midnight. That says that if the company is filing, let's say for example, Accenture is putting an individual at a company called Tesla, for example. So both Accenture and Tesla has to file a H-1B?
Yeah, somehow they've completely modified what it means to be an employer and created this fake term called secondary employer, and claiming that Tesla is the secondary employer of this person, even though they have no role in the employment relationship whatsoever, and now Tesla has to file an H-1B.
What are you speaking, Emily? Are you speaking, which language are you speaking? The doctors, if they are placed at a hospital, you're telling that the private practitioners company that put the doctor out there have to file a H-1B, and the hospital has to file a H-1B for them. So they're telling both the doctor's office and the hospital both are employers of when the person is working at the hospital?
Right.
Well, in Texas and most of the states in the United States, the hospitals cannot employ doctors. How can they file a H-1B?
Right, exactly. I think that this is, it is a midnight regulation, which Biden has also said he intends to block all of those that have not actually taken effect from taking effect. So this is one that's not going to take effect until later this year. Therefore, it should not actually go into effect if Biden follows through on that. But even if it does, I think it would be struck down so quickly. There are so many legal issues that this is basically rewriting employment law, not just immigration law. I mean, it's like saying that if, Apple contracts a company to come mow the lawn at the Apple building, now all of a sudden that lawnmower is an employee of Apple too? I mean,
So you're going to say all our clients are our employers, right? It doesn't make sense. I think so they're done away with the Supreme Court decision of hire, fire, and pay and give the benefits. They've done away with everything, and this regulation, midnight regulation, is a nightmare, Emily. And then because two employers have to file, approximately around 40 to 50, 60% of the entire H-1B population right now in the United States are working for consulting companies. Especially in the medical field, the doctors cannot work with hospitals. In most of the states, they cannot employ them. They are working through some other companies. So that's going to be a nightmare if this regulation, it's going to become effective, and it's a problem though. The whole people have to leave the country. That's unless Biden administration stands. One problem I have in is he's going to undo all the things. Did he said that?
well, he said
Yeah.
that he would either delay or halt anything that has not actually taken effect yet. So these are final rules that have been published but not taken effect yet.
I only hear of one thing, the Keystone Pipeline, he's going to undo that. I didn't hear about all these things. So it may be very important for all the people who are affected by this particular regulation to contact your congressman to make sure you put a pressure on the new administration so that the Biden administration blocks this. We know Biden administration is proactive on immigration, unlike all the administration that I have ever seen, including Clinton's administration. He definitely seems to be very proactive. But yet, while this bill is going through, if he neglects these regulations, it's going to be a nightmare for us. Emily, since EB2 and EB3 seems to be that sometimes EB2 moves faster, sometimes EB3 moves faster. What do you suggest of the people who are getting their labor approved right now? Should they do, should they try to do EB2, EB3? What should they do?
Yeah, I think anytime that the labor is certified in the EB2 category, you should be eligible to file in either EB2 or EB3. And nowadays, perhaps it's easier to get the dual option if you're filing both at the same time, right when the labor is approved. So we're not in a situation like October where people had I-140s from years and years ago that they're trying to downgrade plus file the 485 very quickly. So you may want to consider, if you are going through the labor certification process for the first time or even going through it again due to a job change, and especially if you're porting a priority date from a previous I-140 petition, check to see if your employer will be willing to file both at the same time. It's easier to prepare.
They can file both at the same time?
Absolutely. It's easier to prepare them both at the same time compared to preparing and filing one now and one 2 years from now. So it kind of might make more sense, more efficiency to get them both done now. That way you've got them both set and you're good to go whichever date becomes current first.
Emily, on the wage level of H-1B lottery, I am now confused completely. Explain it to me. Now there is a new regulation that says that the prevailing wages have gone up and they are becoming effective on July 1st. Now you're telling that the H-1B lottery system has to go based on the wage level. All the audiences know that there are 4 wage levels. Level 1 is the lowest wage level. Second, wage level 2, level 3, wage level 4. Wage level 4 being the highest. So did the wages went up? Remember that they went before and the court said no, and now there is a new regulation that comes into picture which says that they are becoming effective on July 1st, at least that's what they're reading. And now there is another regulation that says that H-1B lottery system will be based on the wage level. Explain that to me, Emily.
Right. So Friday, well, I guess it was before Friday, but we had a final regulation issued that again recalculated the prevailing wage levels, which basically increases the prevailing wages that need to be used for H-1B and labor certification filing. This is the same regulation that was blocked by a court in October, but now they've modified it based on the comments and issued it as a final rule. So it is issued, published, it's final, but it won't take effect until July 1st. So the wage levels will remain the same through the rest of this year. Typically July 1st is when the new prevailing wages come out anyway, so it's at a normal time to make that change. But so that's not something that's going to impact the upcoming lottery applications because those have to be filed by June 30th. However, we have another regulation that was also finalized that is going to take effect in March that basically distributes the H-1B lottery based on wage level, not random draw. So they're looking at if you are if your position offers a level 4 prevailing wage, then those people get to be selected first. If there's any leftover H-1B visas available after using up all of the level 4, then they'll start looking at level 3 and issue the visas to level 3. Based on prior year filings, I don't think anyone who's level 1 or level 2 would have any chance of getting an H-1B this year. And most likely everyone's going to jump to try to get into level 3, which means a lot of people who are in level 3 may not make it this year. All that to say, obviously we have a new president tomorrow. Again, he's already stated that he plans on blocking or halting or delaying all of these so-called midnight regulations. So hopefully we will have an update tomorrow on whether this particular regulation is actually going to go into effect for this year's lottery.
Let's go to some questions. Archie has this question. Can I invest in Bitcoin and earn interest and get a 1099 from Bitcoin? Since it's a investment, you are not participating or you're not working, you can invest. Please take our advice only for the immigration matters. We are not here to give you financial advice, and we're not good at it at all. So it's up to you how risky you feel about it, but we have no knowledge about how the Bitcoin works. But what we can tell you is that as an immigration lawyer, yeah, you can invest in Bitcoin. If you get any 1099 on it, that is not going to cause any problem whatsoever at all for any of your non-immigrant visas or green card. The same thing goes to all the stocks, though, that are in the market, except we do not advise anybody to buy any stock related to cannabis or what you call weed. Please, you need to get an advice from an immigration lawyer before you do anything. But as far as the regular stocks like Apple, Tesla, whatever those companies are, you're fine. You can invest into those stocks. You can make money. You can get the dividend. You can sell the stocks, make money on it. You can get the 1099 and you're subject to taxes, and you just have to pay the taxes. But otherwise, you're perfectly fine, no problem whatsoever at all if you're investing in the stocks.
Chandra from Facebook is in H-1B status. His 6-year limit is going to be reached January 2022, and his perm was recently filed. He wants to know what happens if the perm is rejected. Is there any way to continue in the U.S. in that situation? So assuming that the perm was filed 365 days before your actual 6-year limit is reached, if the perm is ultimately denied, the employer does have the option of filing an appeal, and that appeal is considered as if it's still a pending perm to allow you to get a 7th year extension, just 1 year, while based on the pending appeal. Once you have that 1-year approval in place, then they can possibly refile the perm if the appeal doesn't look like it will be successful. So there are some possibilities to extend even if you get a very late perm denial that's unexpected.
So I'll ask this question. If the new immigration reform bill will it benefit people who have STEM degrees, STEM master's degrees, we yet don't know, but we're just taking a guess. Based on the previous study of it, we're expecting that more green cards to be allocated to the employment-based, particularly for those people who have a master's degree in the United States and in STEM. This is based on the 2013 bill at the time when Obama was there. Biden was the vice president at that point of time, and he supported the bill. So we may see those kind of provisions in the Biden bill.
Shiva from YouTube wants to know, if his wife starts working using the 485 EAD, will her status change from H4 to AOS? Yes, that's exactly what we talk about marrying the adjustment of status, especially for those that just filed in October. If you use the 485 EAD that you receive, you're no longer considered to be maintaining H4 status. And he wants to know, what is the validity of the I-94 in that case? The I-94 generally becomes irrelevant once you are in adjustment of status. You continue to be lawfully present and can work using that EAD as long as your 485 is pending, even if your I-94 expires.
Abir is asking this question. There is a receipt date on his 485 application, and there is a receipt date on the 485 application, and there is also notice date. Yeah, that varies though, because on the day the immigration receives your application, that is the receipt date. On the day they issued the notice, that means that when they issued the receipt notice, that will be the receipt notice. For all practical purposes, for you to count the days, it is since the time the immigration received your application, not when they have issued the receipt notices. So when they got the document of you, that is the day when it counts, not when they issued a fee receipt to you. That doesn't count. So especially for 180 days, it is on the day your application has been reached to the immigration. That's when 180 days starts counting.
Anand from Facebook is on H-1B and wants to know, if you stay outside the U.S. for a year, you get paid in your home country during that time. Will it affect your H-1B status? Well, if you're physically outside the U.S., you're not in any status, because that only applies when you're inside the U.S. So you can do whatever you need to do when you are in your home country. Your H-1B approval notice remains valid until it expires or until your employer withdraws it. And your visa remains valid. The visa stamp in your passport remains valid until it expires. So if that job offer remains available to you a year later, and the H-1B petition has not expired, you can come back to the U.S., assuming that you're coming to work for the same company, same terms and conditions of the previous H-1B approval.
Srinivas has this question. Are they considering anything for the H4 kids? It's a good question, though, for the new bill, especially when they're going to age out. One problem with the immigration that I've seen in the United States, the bill that passed in 1985, though I was not a lawyer at that point of time, when the bill passed, it was the Reagan administration that passed it. So when they passed the bill, though, they said only people who are unlawfully present in this country could get the green card. That was really sad. I mean, why not the law-abiding citizens, law-abiding students also should get benefit? I don't have an answer why they did like that, but I remember that in 1985, when the bill was passed, they said only people who are unlawfully present in this country could benefit from the program. We have seen the same thing in the DACA also. Those people who are unlawfully present in the country, they got the benefit, but the people who are lawfully in this country did not get the benefit. That is really a sad story. We have to see, we need to put our efforts, we need to write a letter to the congressman. What about the people who have been abiding? Are you telling the kids not to abide by the law? So that should be a good question, though. I mean, I remember back in those old days, we were trying to prove our clients to be unlawful. I mean, the government is telling they're lawful, and we're telling they're unlawful. It was really a different scenario at that point of time, though. So it's a point to be noted, Srinivas. It's a point to be fought for. It's worth for fighting that one.
Sonnets from YouTube wants to know, what are the chances of this new H-1B and wage regulations being taken back by Biden so that they won't go into effect for this year's lottery? I feel like it's probably a 75% chance that Biden will block those. Whether it's going to be completely blocked or just delayed, we don't know yet. But it seems to be that he is planning on, and can be done more by an executive order. It doesn't require a regulation. Every incoming president issues this kind of executive order to block midnight regulations from the previous president. So I do think it's very likely that it will be blocked before it takes effect.
Kaushik has this question. I have a pending I-485 and I-140 EB3 downgrade. Once the 180 days passes, can I just move on H-1B and AC-21? My employer, he's saying that his employer is not going to withdraw the I-140. That is a very, very risky step, though. If your I-140 is approved, you definitely are relatively much safer as compared to when your I-140 is not been approved. So that is a big risk that you're taking. I would recommend that you wait until the I-140 is approved. And why can't you do premium processing? If your employer is that cooperative, file I-140 premium processing. There are some lawyers who are telling premium processing is not allowed. It is allowed. Is there a chance that they may reject your premium processing for the downgrade application? There is a chance, but please note down that even if they reject the premium processing, it's only the premium processing that they are rejecting, not your I-140, not your 485, and guess what? They will give the money back. Normal immigration never gives the money back. But when they do reject the premium processing, your money will be given back to you. So for all considerations, do the premium processing.
Anik from Facebook has a STEM extension OPT that's expiring soon, also has filed for the adjustment of status and has a pending EAD for that application. Unfortunately, with EAD processing times, most likely the EAD won't come in before the STEM OPT expires, so he wants to know if he should enroll in a new degree program so that he does not marry the green card process. That is definitely an option. It's the reason to not marry the green card process is it gives you a backup plan in case something goes wrong with your green card. If you are married to your adjustment of status and that adjustment of status gets denied, you have no status. You're immediately out of status, immediately unlawfully present. It's very hard to get back into proper status from that situation. So that's the main reason why people choose to continue the non-immigrant status so that they can avoid that risk. Now, that risk may not be that great of a risk in certain cases. If your I-140 is already approved and everything looks great for your 485, the chances of a denial are relatively low. Definitely you'd want to discuss that with your attorney who filed that 485 for you to see what are the likelihood, what is the likely possibility of a potential denial there before you make that decision.
D is asking question, what is the priority date? How do you consider? Is it on the day the I-140 is filed, I-140 is approved, on the day labor certification has been filed, firm labor certification has been filed? The answer is, it is when your labor certification has been filed, that will be considered to be your priority date. If by any chance your I-140 has some mistake or error, you can always have them corrected, not a big problem. Kiran from YouTube has this question. I filed adjustment of status because of prior date is current. My son is turning 18 this year. I-140 is approved in 2001. He's going to age out when he turns 21. What does he need to do? Kiran, we already recorded the video. We're going to present it in next 2 days. I want you to watch that. In that video, Emily has presented very good with regards to called age of the kid. The natural age of the kid as compared to, she calls it as CESPA age. That means Child Service Protective Act age. So there are two different ages though. And she has defined it very well. It's going to take a little bit long time, but We're going to, please watch the YouTube. 2 days from now, we will have it. We already recorded it. We just need to upload it to the YouTube. We'll upload it in the next 2 days. Please watch that video. Everybody whose kid is in adjustment of status, whose kid is in adjustment of status, and they are 12 years or older should watch this video that we are releasing it in the next 2 days. We already recorded it. We are just going to upload it in the next 2 days.
All right. Fareed from Facebook has questions regarding H-1B transfer and the impact on the H-4 spouse. So in his case, filed an H-1B transfer from employer A to B, already got it approved. At the same time, he, at the time of that H-1B transfer, his spouse's H-4 extension was still pending from employer A because they're taking 23 months at the California Service Center. So he wants to know, does employer B need to file that H-4 extension? Well, it's not mandatory for the new employer to file that extension because your wife will be eligible for H-4 status as long as you're maintaining your H-1 status, whether it's with employer A or employer B. The reason some people choose to file another H-4 extension with the new employer is so that you'll both have the same end date on your I-94s when all is said and done. So it's possible that if you use the existing H-4 extension that's pending with employer A's approval, her I-94 may be a little bit shorter than your I-94 that you received from employer B, but no problem with that.
Naveen has this question. His payroll amount is less than LCA. Will that be a problem? If you have some leave periods, especially when you visited India and they didn't pay you the salary and your LCA, your W-2 wage is lesser than LCA, that's understandable, explainable, and perfectly legal. But if it is otherwise, other than you being on the leave though, you may have to contact a lawyer to discuss the options you may have.
Amit from Facebook says he's worried about this midnight regulation requiring the end client to file an H-1B. What are the different paths that will lead to cancellation of this regulation? So I would not be super concerned about it at this moment because it doesn't take effect for several months. So there's time. We have the new president coming into power who is expected to block or halt or delay any regulations that haven't taken effect yet. If that doesn't happen, I guarantee you there's going to be lawsuits on this one, and I think they would have a very good chance of success because it completely redefines what it means to be an employer, creates this fake idea of a secondary employer, and the Department of Labor didn't even issue it as a regulation. They just issued it as interpretive guidance. You can't change your interpretation without any possibility for notice and comment. They just published it and said, this is what it's going to be. No ability for us to comment on it. I think that's going to be struck down.
Wouldn't they have a defense saying that it's based on the regulations for the USCIS?
There's some legal hiccups in that. They have to have their own regulation from what I've seen. There's a lot of different legal arguments that can be made to block these two things from happening.
Especially we want to update you also on two other litigation things that we were discussing is, one is that when does the age out of the kid is it on the date of filing or is it on the date of the final action date? The USCIS is interpreting as the final action date. There is already a court litigation which we are following up very closely, and we're monitoring if necessary. We're going to interfere into that, where the lawyers are arguing that it should be the date of filing, not the final action date that should freeze the age. We also we're getting a lot of calls from the people, Emily, where are they going to use the 250 or 260,000 green cards this year? The way they are moving the priority dates doesn't look like they are going to use it. Also, the way that they are doing the biometrics, the way the processing periods are there, they may not be able to use the 250 or 263,000 green cards that are allocated to the employment based. And if they are not used, they'll be wasted. We are in discussion with Washington, D.C. lawyers to see what legal basis we have. It's going to take a little bit time. We are working very extensively on it. We will update you. We will include you. I know a lot of people are offering that I'll pay the money and all those things. Just hold on. We need to have the legal basis. We're trying to find it. and we will update you as we go on. If necessary, we'll release a separate video just for that only.
Mancy from YouTube wants to know, will the backlogs in H4 improve with the new administration? I think that over time, yes, but there's such a backlog right now that has been created by the biometrics being canceled and then not rescheduled and COVID and all of those things, that it's going to take time. You know, when a new administration is coming in, they really have to change the culture and mindset of the agency, and that does not happen overnight. So yes, it should improve because 23 months is absolutely ridiculous. Will it improve quickly? I don't know. And you know, we also have the potential for the H4 premium processing, which was passed by Congress, signed into law by the president, but USCIS is dragging its feet on implementing it. So hopefully we will see some action on that. But again, I think the Biden administration is going to be more focused on going with immigration reform, the congressional route, and that may be a secondary action to be taken later.
Ajay has this question. When is the premium processing coming into? Premium processing for H4 EADs coming in? We yet don't know. With the new administration, they may roll it very quickly. That is what we are estimating it to be. This administration seems to be taking very aggressive steps. Looks to be that they are trying to cover the mistakes that what has been done in Clinton administration and in Bush administration, in Obama administration. This administration seems to be very aggressive. That seems to be, and they're in good terms with immigrants, guys. They're not like the Trump administration. Trump administration was also very aggressive, but they're in the opposite side of us. This administration is on our side. They're taking very aggressive steps based on the way that he's moving on. First day on inauguration, he's going to unveil the immigration bill. Never seen that. I mean, never seen that. That is very aggressive, and it should be welcomed by everybody to resolve the problems that are there.
Oh, question, I just lost it, but the question was, can a person, this is Srikanth from YouTube, can a person who is now in adjustment of status change back to H4 status without leaving the country? And the answer is no. The only way to continue H4 status or change status to H4 is if you're in a non-immigrant status at the time of filing. Adjustment of status is not a non-immigrant status. So the only way to get back in H4 status is to exit, get this visa stamped at the consulate, and then return.
Shanaz has this question. Can my husband legally stay in USA while F2 to H4 change of status is pending? What is the current timeline? Shanaz, yes. If the person's H4 is pending, he can stay in United States. He doesn't have to leave. The current processing time, depending on which service center they have allocated this file to, may range from 8 months to 20 months. But he can stay in United States, absolutely not a problem. Please note that when it is H4 to F1, the rule is different. But when it is F1 to H4, they can stay in United States. You do not have to file any bridge application also, you're fine.
Sahil from YouTube wants to know, can I switch to a TN visa if I have an I-140 pending? That could be problematic because the TN is very clear that it is not a dual intent visa. You have to document your non-immigrant intent and convince the officer at the port of entry where you're applying. Typically, if this is Canadian TN, you would be visa exempt and not need to apply at the consulate, but you still have to convince the officer at the port of entry of your non-immigrant intent and that you intend to return to your home country at the end of the TN stay. Having a pending I-140 kind of says the exact opposite, so it definitely can be a problem.
Question, can a H4 EAD be filed along with the H1B amendment? This question comes from Mukesh. The answer is yes, you can file H4 plus EAD along with the amendment, not a problem at all.
Aaron from Facebook wants to know, what is the preferred option for college-going kids, H4 or F1? Good question. Obviously, once they turn 21, F1 is the only option. H4 is simpler, but does not allow for work authorization. So your college-age kid won't be able to get that summer job or do a summer internship and gain the skills that they need for when they graduate. So that's one of the downsides of the H4 versus the F1. You have the potential for a CPT to take a summer internship. You have the OPT after you graduate. And there's also a difference in tuition generally between H4 and F1 if you're considered a resident or international student, very different tuition rates.
Srirang has this question: can a H4 EAD do the medical residency, or is it J visa better? Definitely H4 EAD can do medical residencies. J1s are a good option too. The downside of H4 EAD is sometimes when you extend the H4 EAD, it may or may not come in time. That's the only downside of the H4 EAD. Otherwise, I would definitely prefer H4 EAD though. The downside of the J1 visa is that it's easy to get into J1. It's very hard to get rid of J1. To move from J1 to another visa, especially for a medical residence, it is a long way, long path, lot of difficulties. You need to consult a lawyer if you choose to get the J1 visa. Consult a lawyer before you do anything on it.
Nisha from Facebook has a visa that will expire in August of 2021, but the passport is expiring in August 2022. She wants to know if she needs to renew the passport first and then apply for the extension, or can she apply for the extension without renewing the passport? So I'm assuming you're in the U.S. in H1 or H4 or some kind of non-immigrant status, and will be filing the renewal of that status with USCIS. In that situation, it is not necessary to renew the passport first. You just have to have the passport valid at the time you're filing the extension, which yours would be. Now, if you then get that extension approved and travel, if you're going to travel and you come back in on the expiring passport, your I-94 will be cut short at the port of entry. So you have to keep an eye on that if you're not going to renew your passport before you travel.
Does the NVC issues green cards for the spouse of the green card holders? Now, it's not the NVC that issues the green cards, it has to be the consulate. The problem with the consulates right now is they are backlogged because of the COVID, and there is another problem. For the preference categories, which green card spouses are considered to be preference categories in the family immigration, the Trump administration put a ban on it. I mean, you can't get it, so that's another problem. You have it. That ban is expiring on March 31st. Biden administration is expected to undo that executive order though, but Biden administration is not expected to open up the consulate as fast as he can. He is not expected to be very aggressive because he's more defensive with the COVID. So he's more not opening up those kind of things is what his opinion. We all know from the beginning what his opinion is. So he may not open up the consulates as fast as possible, but he definitely is expected to undo the executive order issued by the Trump administration.
Rama from YouTube recently renewed the passport, has the valid H1 visa, but the I-94 is going to be expired soon and wants to know if the I-94 needs to be extended. Yes, that is something that I just had mentioned about the shortened I-94, and if you don't realize it, you can end up overstaying and being unlawfully present. There are a couple of ways to extend your I-94. If you already have a valid approved petition and a valid visa stamp, it's just your I-94 was cut short on your last entry because of the expiring passport. You can travel again, and when you return to the U.S., you'll get a new I-94 that you'll print from the online CBP website. That should have the full validity period since you have the new passport now. You could file an extension with USCIS. Even though you already have an extension approved, likely you'll need to file it again because you have to have a valid I-94. Depending on the situation, you could try deferred inspection. Each CBP office at the airport generally has an I-94 email address or a deferred inspection office where you can go and ask them to correct your I-94. A lot of times they won't do it because they don't feel that it's a correction. There wasn't an error made. It's just you have the passport now, which you didn't have before. So those are your 3 ways you can remedy that situation.
I want to update everybody on a couple of different things. One is the consulates. Consulates are still very restrictive right now. We have seen some openings in the US consulates in India, especially in the last week of January. We have seen some of the consulates, when they are given appointment, they have canceled it. We have to see if the consulates are going to keep up with the appointments that were granted in the last week of January. We'll have to see if they're going to keep with it. Overall, there is a lot of, if you want to make an appointment, they're backlogged very significantly in the consulates. If you are planning to visit, though, don't count on it. Try to wait until a week before you have an appointment. Make sure that the consulate is not canceling the previous appointments. Sometimes it may not be the US government, sometimes they may be adhering to the local governments where they are sitting at, the restrictions that the local governments are putting to the general public. The consulates may try to follow those things. They don't, even though they are not under obligation to follow, but they try to follow those regulations to put on them. So these are all the things that need to be noted if you are planning to travel. Questions on the adjustment of status. How does this adjustment of status work? Some of the people are reporting on the YouTube and Facebook that they have went for the biometrics today and the biometrics office was closed. Because of the inauguration, and you know what Trump did and the Trump team wants to do, based on that, the government has practically shut down their offices for the next 2 days. So biometric offices are closed today and tomorrow. They'll be open again. If your scheduled appointment is either today or tomorrow, they will reschedule your appointments. Questions are also coming. If the biometrics are not being held, will I still get an EAD or advance parole? Biometrics have nothing to do with your EAD and advance parole. Even though your biometrics have not been conducted, you could get an EAD and advance parole. No problem with that process at all. You will be fine in getting the EAD. A lot of people are asking questions, when would I get the green card if I get an EAD and AP advance parole approved? Number one thing that you need to understand is that your final action date has to be current. If it's not current, you cannot get the green card, period. Normally, they may call you for the interview before the final action date is current also. That is very possible. They may even exempt you from the interview. That is a possibility right now. Because of the COVID situation, they're exempting some of the people. Now, when I say that, why do they call for the interview when the priority date is not current? They want to make sure everything is ready and make it everything ready, interview you, done with it, so that when the priority date becomes current, they can just approve the case. That is normal, that goes on very frequently. But for the people who have filed the adjustment of status in October though, based on the processing times, it may take at least 1.5 years at least for you to get to the interview stage. Please have patience for that. You're not going to get the interview immediately. Have patience for it. It will take 1.5 years at least for you to get the interview.
Oh, let's see here. Arun from Facebook wants to know if a child's passport can be renewed while the 485 and advanced parole are still pending with USCIS. Absolutely no issue with that at all. Suresh has a question about different SOC codes between different green card applications and H-1Bs. He has an approved I-140 that has one SOC code and wants to know if he needs to file the green card with his current employer to extend his H-1B beyond the 6 years because his H-1B is a different SOC code. So if your previous I-140 has been approved for at least 180 days, you can use that I-140 to extend your H-1B with a different employer beyond the 6 years, regardless of the SOC code. Now, do you need to file a green card with the current employer? Eventually, yes. If you want to actually receive the green card, when it's time to file your adjustment of status, you need to have an I-140 in place with your current employer in order to make that happen.
What are the chances of biometrics to be removed for the H4? We don't know yet. They definitely have taken an aggressive step in a favorable way for us. We need to see if they're going to undo a lot of these restrictive things. What did they achieve by biometrics? They did biometrics for, I don't know, million of the people in the past 3 years or 2.5 years. Did they got at least one terrorist? Did they? What are they doing? If they have not got any one of this, why did they waste all these resources? Why can't they keep that money to the Secret Service or whatever it is to catch those culprits and get them? What is that they have to do with these 2-year-old kids going for biometrics? What is this? These 2-year-old guys don't need to go for biometrics. It is not. It's definitely not fair. But what it is right now is to make sure that the new administration knows it, understands it, and comprehend the complexities that the previous administration has created and take the hurdles out is very important for this administration. At least the way that I'm looking at this administration, when Biden administration is telling that they're going to introduce a bill on the first day, that means that they are very serious. They are looking into the things very seriously. The people, the advisors, and the department heads of the USCIS and the DHS, I am sure that they are aware of all these things. We need to see if they would change these things. We don't want any of the criminals to come into this country. We don't want any of the terrorists to come into the country. Put the restrictions, arrest them, do whatever you have to do. That is agreeable, but why the innocent people need to suffer for all these things? So hopefully, the new administration will do much better than the previous administration. Let's pray for it, and let's also support this new administration, the efforts that they are doing. And also, we will have to bring our problems to their knowledge. That is absolutely important. If there is anything where you see that injustice is done to you, we want you to write a letter to the congressman. Please write a letter to your congressman. Write a letter to a senator. They will understand it. We have seen what happened. A lot of people have contacted the congressman for H4 EAD delay. You know what happened? The 30 or 60 congressmen wrote a letter to the new administration to take the biometrics. They have offered a lot of alternative choices. And if Biden administration picks any of those choices, that is good. I mean, because you contacted the Congress, these things will get attention for the administration. 60 congressmen, I'm not sure if it's 30 or 60 congressmen, wrote a letter to the new administration to take the biometrics off or to automatically grant an EAD and then do all the paperwork later on. And if there is any problem, yeah, you can just do whatever you want, but give the EAD faster. That's what they recommended. So let's see how the new administration works in. They haven't yet come to power. They're coming to power tomorrow. So let's hope that they will do much better than the previous administration.
Soleja from YouTube, I think, has the question of the day on that topic. Can we expect any good news tomorrow for legal immigration? I think that we'll have good news in the fact that the president is intending to move forward with immigration reform that includes reform for legal immigration for much of the issues that people who watch these episodes face. So that is a good news. I think that we'll see regulations that have not taken effect yet blocked, which can be good news for all of these midnight regulations that the Trump administration has been trying to pass to limit H-1B visa use. And then I think we'll just see a very different tone from the administration, a more welcoming, more inclusive, understanding the value that immigrants bring to this country. And that tone itself is going to be quite refreshing after the last 4 years.
Good question. I want to add some of my comments to it. The fact that the Trump is going out is a good news. Believe me, it is a good news. Having said that, I don't know how we survived these 4 years, guys. It was torturous being an immigration lawyer. Everything, rejections in the H-1B, rejections in the amendments, rejections in the extensions, H-4 EAD delays, biometrics comes into the picture. Then we have the 944 application to be added. Receipt notices are taking 3+ months to get a receipt notice. Delays in everything, denials in everything. I mean, how we survived these 4 years seems to be very similar to how those Jews survived in the Nazis. I don't know how they survived, but that's how we survived in those 4 years. So yes, it is a good news that this administration is going out. This is a good news. The new administration definitely is not having the same opinion as the previous administration. So yes, it is a good news that Trump administration is going out. That by itself is a good news. Even if all the other things what Emily has said might be good news, but number one thing, this Trump administration is going out. That is a good news.
All right, well, I think we're about out of time for today. Thank you so much for joining us. Stay tuned next week, and we'll let you know what all updates we have with the incoming administration.
Thank you very much for tuning in.